Software licensing. One of the increasingly common types of contract that you come across is that for software licensing. In this podcast, I will explore a number of issues relating to it, including whether a software licensing contract is a license or a contract, and why that might be important. I will look at custom development and whether a license or a more fully formed contract, including perhaps for the transfer of ownership of the copyright, is useful. Support and maintenance agreements, interoperability and the risk of vendor lock-in, as well as escrow. I will conclude with a few words on the issue of refunds for software purchases. The starting point, as I said, is that there is an ongoing legal debate whether a software license is a license or a contract. And if you've studied intellectual property or land law, you'll probably appreciate that a license is a bare permission to do something. The very description, software license, perhaps presupposes a conclusion that when you license software, what you are getting is only a license. Similarly, if you work through the various aspects of contract, offer, acceptance, and consideration and so on, in the context of one of these documents, you may or may not think you can make out the basis of a contract. It completely depends on the terms of the document in front of you. In some cases, a license for software will be part of a much broader agreement, and in that case, finding a contractual basis will be relatively easy. Where there is nothing but a document which looks very much like a license, the situation is perhaps more questionable. Although some say this is quite an academic debate, I think it's actually quite an important one, and it matters for two reasons. First, it has an impact on the remedies which might be awarded, and second, it has an impact on the requisite proximity in the relationship, the ability to bring a claim. In terms of remedies, the general rule, as you know, is that breaches of contract are remediable in damages. For an infringement of copyright, it will likely be easier for the claimant to obtain an injunction, even if only as an interim step. If you want injunctive relief, arguing on a license and a copyright basis might be preferable. With respect to bringing a claim, the general principle under contract is that only a party to the contract can sue or be sued under it. We have already discussed third-party rights, but these are rights and not obligations. If we take the situation in which I contract with you and the contract is the basis of your right to use the software, if you give the software to someone else and they use it, I may be able to sue you for breach of contract, but I'm unlikely to have a contract law claim against the third-party user. If, however, my claim is in copyright, I may be able to sue you for copying the software and passing it on outside the scope of your license, and I may also be able to sue the third party directly for infringing my copyright. It may be a very pertinent issue. Not all software necessarily comes off the shelf, and you may be in a situation where you're looking to someone to develop software for you or to customize existing software to your needs. Have a think about what you're expecting in that circumstance, what you need for your business, and whether simply getting a license is sufficient. Are you expecting to own the copyright in the software, for example? If you are, you will want the copyright assigned to you, and you'll need to ensure that this is done properly. As you may recall from one of the very beginning podcasts, this is one of the situations in which particular formality is required in the form of signed writing. If you have taken a copyright course, you may remember that the first owner of copyright is the author of the copyright work, with an exception for work produced under a contract of employment. If you are paying a third party to do software development work for you, whether that's through a traditional company or through sort of an online freelancer service, you're probably not entering into an employment relationship, and so you don't benefit from this exception. In that case, if you are expecting to own the copyright, make sure you get it assigned to you properly. You may also want to consider the extent to which your supplier, your developer, can use free and open source software. It may bring the price down, but make sure you understand your compliance obligations just as you would with any third-party software. Similarly, to the extent that you require particular coding practices to be followed, such as how the code is documented, what you're expecting to get in the way of documentation. Make sure this is clearly spelt out in the development agreement. Depending on what the code does and whether you intend it to be a competitive differentiator or not, you may want to agree to license the code instead of buying it outright. Alternatively, if it is something which the developer thinks they can use again and it may reduce in a lessened price, you could take ownership of the code but license it back to the developer for exploitation under sort of pre-agreed circumstances. Do think whether simply taking a license is what you want, or whether something that affords you the ownership of the copyright may be more suitable for your needs. In addition to whatever licenses or permissions you may require simply to run the software, you will probably want to have a think about support and maintenance of it. If you read the IT news, security vulnerabilities are discussed on seemingly a daily basis, and leaving a system unpatched, especially one that's connected to the internet, could be a very unwise move. Aside from security issues, software is very rarely, if ever, perfect, with most software demonstrating at least a handful of bugs or other undesirable behaviours. How are you going to get those fixed in a timely manner? Is this something you're willing to pay the vendor for, or are you going to try and do it yourself, which brings with it its own requirements? Vendors are often very happy to sell a subscription service under which they will provide software updates, security updates, patches for a fee, perhaps an annual subscription. You may find that a vendor is willing to do this for as long as you use the software, but often you will find it linked to a particular software release, a particular version of the software. Once their software moves to another major version, for example from version 7 to version 8, or perhaps has moved forward a couple of versions, they may want you to move to their latest version, probably at an increased license cost, if you want to continue to receive support and maintenance. Does that fit in with your business plan? Make sure you've considered this kind of thing up front. Make sure you plan this out in advance and document in the contract exactly what it is that you're expecting to receive. This is probably a situation in which a service level agreement will be desirable too. You may not be too worried whether the colour of a particular button takes a month to fix, for example, but you're likely to want security patches faster or defects that are holding up your business to be fixed quite quickly. Similarly, if you need the vendor to provide operational technical support, for example as a supplement to or replacement for your own IT support service, you will want to ensure that high priority calls, those that really are stopping your business from running, are handled very quickly, while those with more general questions can wait. Making sure you get the service levels set correctly with appropriate incentives for meeting those targets is going to be very important. As with anything on which your business relies, if you do have a viable alternative arrangement and a business continuity plan to ensure a smooth, planned transition, your business is in the hands of trusted third parties. If you do not have this, you are locked into the products and services of one party, and this is a situation, the idea of vendor lock-in, that's perhaps particularly true of certainly proprietary software. You have something which should be the most interoperable and open of all business products and service, but in fact you are locked down in terms of what you can do to simply what your current provider is willing to support. Imagine the situation in which you have paid a supplier to supply a new customer management system for you. Can you get your data out of the service and into another service if the supplier decides to stop supporting the system? Would that be relatively easy and painless, or big and expensive? This is especially true for cloud services. If they should one day simply shut down, what do you do? What's your business continuity plan? What happens if your supplier is bought out by one of your major competitors? Would you be happy to carry on paying money to your competitor? An approach to consider would be to only use suppliers whose software makes use of open standards and who guarantees that you can export all of your data without any proprietary wrappers around it or formatting or special software needed to understand it. You may also need to ensure that your license for the software permits you to get third parties to modify it, unless you want to be totally reliant on your supplier. Of course, as a supplier, Unless you see this as a competitive differentiator, you may be entirely unwilling to grant such a term, particularly if it requires you to hand over your source code, which you probably consider to be your crown jewels. Both parties will need to work out what they want and what they need from the relationship here. A topic strongly linked with that of vendor lock-in is escrow. Escrow is the placing of the relevant parts of a supplier's software, usually the source code, into the secure storage of a third party, such that if a certain trigger release event happens, you are able to access the source code. This should be coupled with an adequate license to enable you to do or to get the third parties to do the work that you need. And although escrow clauses are pretty common, it's worth thinking about the situation carefully from a disaster recovery and a business continuity planning perspective. For example, just because your supplier has put software into escrow, can you or your chosen third party understand it? Do you need more than just the source code? For example, build information, perhaps a copy of the software build environment. Who is responsible for checking that the code which is in escrow actually builds into working software? If you don't test it, do you really have effective protection, or just another mess to deal with at a time when you probably have more than sufficient problems on your hands? Who bears the costs of escrow? This is probably an annual payment, and if not kept up, the escrow agent may no longer keep a copy of the software. What are the trigger events for a release? Is it limited to the circumstance in which the supplier goes into liquidation, for example? What if they simply decide no longer to support the product? Partly this is a commercial issue, as the supplier will want to limit the trigger events that are available. But also for you, probably a business continuity planning issue, as you will want to ensure that you can continue to run your business. Of course, if you're a supplier in this kind of situation, you probably want to minimise the situations in which your source code could go into the hands of a third party. You want to limit the release conditions quite tightly to the situation in which you are no longer able to support that software. The fact that you've chosen to move on in the versions of the software and your customers are running very old versions may simply require them to move to more current versions rather than for you to have an ongoing obligation of support and maintenance. Briefly, I will touch on refunds for software, and as you'll recall, generally there is no right of refund just because something does not meet your expectations. However, if in a custom development agreement you have specified exactly what you require the software to do and it does not meet your specifications, you should be able to obtain a remedy for breach. In the Online and Distance Contracts podcast, I discussed the extra rights afforded to consumer purchases under such conditions. Since most of what we've talked about in this podcast really is business focused, all I'll say is remember that these rules apply generally to consumers and not to business purchasers, who are expected to make their own arrangements. However, even as a consumer, the right to cancellation for distance contracts does not apply in the case of a contract for the supply of sealed computer software, if the consumer unseals the goods after delivery.